calls case of Coleman versus the Beeline Courier Service Incorporated. Mr. Burke?
Yes, Your Honor.
Mr. Burke, you have 15 minutes and you've asked to reserve 3 of those for rebuttal. All right. And Mr. Byrne, 15 minutes, you'll go straight through. All right. Counsel ready to proceed? Yes, you may.
Thank you, Chief Justice Minton, and may it please the Court, Mr. Byrne.
Mr. Burke.
Statutory no-fault benefits are paid in lieu of claims which have been abolished by the No-Fault Act and compensate for different elements of loss than tort liability proceeds. For that reason, Beeline's release and indemnity in the present case does not include no-fault benefits. The appellee has made the plain language of the general release in this case its centerpiece, so I would like to go to that first. The last sentence of paragraph 2 of the release says the undersigned agrees to hold the release party harmless and indemnify them from any claims asserted by any third parties or lien holders, including but not limited to all medical providers and any other insurance carriers, against the proceeds of the settlement. Also, in the first sentence of paragraph 4, said payment and settlement and compromise is made to terminate further controversy respecting all claims for damages. That release language is consistent with the correspondence between the parties which agreed to settle Ms. Coleman's injury claim. The release contains no specific designation of no-fault benefits within its 4 corners. There's no mention of no-fault benefits in the correspondence between the parties which preceded the release. And the specific designation is required by Ohio Casualty versus Rochelle, which is the case we've principally relied upon here. Under Ohio Casualty versus Rochelle, there must be a specific designation in the release, because otherwise the general release, as stated, can't include no-fault payments when you consider also the language of the Motor Vehicle Reparations Act and this Court's case law as well. In addition, we submit that the policy, purpose, and language of the Motor Vehicle Reparations Act would render any indemnity, as argued by the appellee in this case, unenforceable, even if it specifically designated it. So we're asking this Court to go one step further than what Ohio Casualty versus Rochelle said. And the reason that is because when we look at the overall language of the Motor Vehicle Reparations Act, which is the exclusive remedy for payment and recovery of no-fault benefits, if that's true, then there can't be a contractual indemnity claim, because that's not provided by the Motor Vehicle Reparations Act. Recently, this Court in Neurodiagnostics versus Kentucky Farm Bureau held that a contractual assignment between an accident victim and its medical provider was unenforceable because of the language of the Motor Vehicle Reparations Act. Essentially, you couldn't assign no-fault benefits to the medical provider because that isn't in the language of the Act. And if it's not in the language of the Act, it's not allowed. Neurodiagnostics didn't deviate from previous case law in that regard. In fact, in Fireman's Fund versus Bennett, this Court, or I believe this Court of Appeals, held that common law indemnity claim for basic reparations benefits was not allowed because it's not in the language of the Act. Progressive Insurance versus Kidd held that common law subrogation principles didn't apply, only the language of the Act. Smith v. Earp, which is a Western District of Kentucky case, held that the loan receipt practice for basic reparations benefit didn't apply because it's not in the Act. So Neurodiagnostics versus Kentucky Farm Bureau was just an extension of that. And so if we look at that, if we look at those cases in the language of the Act, we have to ask ourselves, what policy or purpose are we advancing by allowing indemnity of no-fault benefits? The answer is none. We're not advancing any of those that are listed in KRS 304-39010. The MVRA provides that you want prompt payment to the victims for no-fault benefits, you want to encourage prompt medical treatment, you want to permit more liberal wage loss and medical benefits, but specifically under Section 5, To reduce the need to resort to bargaining and litigation through a system which can pay victims of motor vehicle accidents without the delay, expense, aggravation, inconvenience, inequities, and uncertainties of the liability system. How is that section advanced if you're bargaining essentially away your right to no-fault benefits through an indemnity clause and a release? We submit that policy isn't advanced at all, can't be advanced.
Let me ask you a question just as a practical matter. When the offer, or when the demand for, what was it, $21,000 was made, and the response came back, well, we'll settle everything for the $6,500. If they knew that they were going to be responsible for the to the other insurance company, or to for the BRBs, they would have had to say, no, we can give you nothing, right?
It's, in essence, yes, that they, I'm sorry, when you say they, who specifically?
Okay, the Beeline, yeah, Beeline would have said, no, we're already on the hook for 10, because the insurance company can go back to the other insurance company to get their first $10,000.
Right.
They should have said, well, we don't think it's over a $10,000 case anyhow, so they had to consider that in their negotiating with the victim.
That's correct. Essentially, you wouldn't settle under that circumstance. I mean, as it stands right now, when you had $5,747 in no-fault benefits that were paid. Right. There was a $1,000 intercarrier deductible as a result of arbitration, leaving $4,747. The settlement was for $6,500. After you take out attorney's fees and everything else, essentially, you're at a net loss. Now, that's not a bargain.
Let me call your attention to the language in the paragraph and ask you a couple, in the policy, or the agreement rather, and ask you a couple questions about it. I'm going to omit some words. The undersigned agrees to hold the reasoned parties harmless and indemnify them from any claims against the proceeds of this settlement. The proceeds of that settlement was $6,500. When the injured party's carrier sought through arbitration to get repayment from BRB, could that be said to be a claim against the proceeds of the settlement?
No, it cannot. When Nationwide, the no-fault carrier, made its, that's a statutory mechanism for recovery of no-fault benefits, which is allowed against the liability carrier. And this is another wrinkle in this case. The insurance carrier for Beeline actually is Zurich Insurance, and that's listed in the arbitration notice. Beeline Courier Service isn't a party to that arbitration. Beeline Courier Service, if it is insured by Zurich Insurance, which we don't know, we just don't know the exact relationship of that, they would actually be considered a secured person under the Motor Vehicle Reparations Act. They're not, they can't have, there can't be that mechanism of recovery through arbitration against the tortfeasor, only its liability carrier.
But it was Beeline who made the payment?
No, we don't know that.
Don't know that either?
No, we don't, that's not in the record. So, and we don't, again, because...
Beeline is self-insured, correct, and a claims administrator?
No, we don't know that. And that was, we think that could be the case.
Gallagher Bassett.
Right, you have Beeline Courier Service, third-party claims administrator, Gallagher Bassett, and then Zurich Insurance. We don't know whether they were the excess carrier.
They'll show us excess in the brief.
I'm sorry?
Now, this is excess carrier in the brief.
The appellees have said that in the brief, but the claims notes and discovery reference $1 million in coverage. That's in the record at 119, the answers to discovery, the claim notes that they've provided to us. We just don't know for the purposes of summary judgment.
So your position primarily, though, is the Ohio casualty case says that if your settlement offer includes basic reparations benefits, you have to so state with specificity.
Right. And that makes sense when you think about it. Otherwise, you run into a situation like this case where you don't, the correspondence between Stephen Price, the claims adjuster for Gallagher Bassett, referenced the injury claim. That's what it says.
Isn't it true that the BRB carrier only has subrogation rights against BRB payments?
Yes, that's correct. That's absolutely correct. Only for the payments that are allowed by the no-fault.
In those categories, yes.
And if those are abolished, there are no claims for those. It's only the statutory mechanism that exists for recovery of that.
I appreciate your diagram A.
Thank you.
It made a lot of sense after I was reading, and I was getting confused.
Thank you, Your Honor.
Put it all together.
I appreciate that.
I have a question for you. When Nationwide, I know Nationwide and Beeline settled, and that's when Beeline went against Mrs. Coleman. Was there actually a lawsuit filed when Nationwide settled with Beeline? I know that, I think in your brief, that Beeline had asked Mrs. Coleman to indemnify them, but was there actually a lawsuit between Nationwide and Beeline?
There was it was an arbitration proceeding, which is required by the No Fault Act, by the Motor Vehicle Reparations Act, and it's basically the parties meet somewhere, and it was between, but importantly, it was between Nationwide and Zurich Insurance. Beeline, again, there's this discrepancy, and we don't know the answer from the record whether Beeline actually did, in fact, reimburse Nationwide. It could have been Zurich American Insurance.
Well, the insurance company for Beeline and Nationwide went to arbitration.
Correct.
But Mrs. Coleman was not brought into the arbitration?
No.
Well, there was a demand made on her to assume the defense.
Correct.
And to pay indemnity.
There was a demand made by Beeline Courier Service, not by Zurich, which was the real party in interest in the arbitration.
And all this was going on before Beeline settled with Nationwide?
Beeline, as far as repayment of the no-fault benefits?
I think the amount they settled for was $5,700 something.
It was
$4,700.
Right. The $4,747 represented the total no-fault benefits minus the $1,000 intercarrier deductible, which is required by the No-Fault Act and the arbitration.
That's what I'm asking. Was Mrs. Coleman, was she involved in reaching, or she will notice when they were negotiating this, had demand been made upon her when Beeline and Nationwide were negotiating all this?
Beeline Courier Service had sent a letter to Mr. Cox saying, we want you to to basically participate in lieu of
participate in that, and that was before the 4737 amount was reached.
That's correct.
Thank you.
With that, if there are any other questions, then I'll just yield my time to.
All right, sir.
Thank you.
Thank you. While we're making the turn here, I'll state what may be the obvious. Justice Abramson is not participating in this case, nor will she participate in the decision-making of the court for the reason, as you all know, she was the trial judge in the case. You may proceed, sir.
It please the court, Mr. Burt, Mr. Cox. My name is Jeremiah Byrne. I represent Beeline Courier Service Incorporated. This appeal is not about Myanh Coleman, and it's not about according to the appellant, the plain language of the settlement agreement. This appeal is about appellant and appellant's attorneys attempting to change the law of Kentucky as it exists today. Under the existing law, Beeline wins this appeal. Under contract interpretation provisions and interpretation principles, the settlement agreement, the indemnity portion of the settlement agreement would allow Beeline to recover the BRB from Ms. Coleman.
Counsel, how did Nationwide, under any circumstance, have a claim against the proceeds of her settlement?
Nationwide had a claim against the proceeds, but not against Ms. Coleman herself.
Specifically, these weren't BRB payments. They weren't designated as that, so the subrogation rights that Nationwide had would have not attached to that. They couldn't have sued her for them.
Exactly. They could not have sued her for them. And Ms. Coleman did not have a statutory obligation to pay these benefits or reimburse for these benefits. She took on an affirmative contractual obligation to do so.
But only if anybody asserted that they had a right to her proceeds.
If they asserted they had a right to her proceeds, and I'll submit that they did have a right to the proceeds of the settlement. Beeline, they had a right against Beeline.
Well, let me back up a minute, and I assume, for purposes of argument here, that you were self-insured, but in this instance, if you'd had minimum liability of $25,000 and you paid her $6,500, you still had $18,500 left on your policy. And Nationwide had a right to come against you for their total BRB, which would have been 10. The only time they would have ever lost that right to come against you if you maxed out that policy and paid it to her.
That's right.
And you didn't. You just paid her $6,500. So their claim is, at that point in time, is against you under the statute, and they have no right to her proceeds because there's still excess coverage of which they can go against.
And I agree. Nationwide had a fully enforceable BRB reimbursement claim against Beeline, which is self-insured under a captive insurance agreement with, or a group with excess to Zurich. Nationwide's claim against Beeline was fully enforceable. Beeline's never claimed it wasn't. But in the process of bargaining for the negotiation and the settlement of this car wreck claim at its inception, Beeline wanted to buy its piece completely from the claim and offered $6,500 to Ms. Coleman, paid her consideration for that amount, and in exchange for that got a full release and a full indemnity agreement, which included the BRB reimbursement.
Mr. Horn, does Rochelle in any way, I know what your answer is going to be, but how do you respond to the argument that Rochelle says that if you want to buy that, you've got to say so?
Rochelle fully and completely supports Beeline's case. And I want to make one quick distinction. The contract issue in this case is a settlement agreement, not an insurance policy. A lot of the law that the appellant has relied upon construes insurance policies. This is a settlement agreement. In Rochelle, the court held affirmatively that as a contract right, the tortfeasor, which is Beeline in this case, in the process of striking a settlement bargain, may extract as additional consideration the reimbursement of no-fault obligations. That's exactly what Beeline did here with this settlement agreement. And
it requires you to state specifically that you're so doing, and you did not.
I'll submit that does cover, and it's in the settlement agreement here, it's clear and unambiguous that it does cover all claims by all third parties, including insurance companies. But if you look in Rochelle to the exact indemnity language the court interpreted, in that case, it is just as broad as the language in Beeline's settlement agreement here, and it does not specifically state BRB or PIP or no-fault benefits. It's just as broad as the language here. And the court in Rochelle predicted the exact facts of this case and said it may be that ultimately, after claimant, Ms. Coleman, is paid BRB payor, which was Nationwide here, will pursue a claim against the tortfeasor, Beeline in this case. And the tortfeasor may seek reimbursement, may in turn seek a right of reimbursement from the claimant, Coleman. The Rochelle case affirmatively states that Beeline is entitled to buy its piece from the case. Indemnity for BRB.
If there's some confusion here about the necessity of specifying in the release and indemnity agreement that it includes no-fault benefits because that was what was at issue, or that's what there's some language in Rochelle to indicate that. Why is that not applicable here? I want to hear you, again, your explanation for that.
The Rochelle case interpreted broad language that to include BRB, just like here. There is no language in Rochelle that says it has to be specifically stated as BRB. It was specifically stated as any claim arising out of the car wreck, just like here. Any claim arising out of the car wreck. There's another portion of Rochelle, another part of Rochelle, which says the real case in Rochelle was the claimant had settled with the tortfeasor first, then sought BRB from her own BRB insurance carrier under the insurance policy. And the court said, yes, you can still get your BRB under your insurance policy, even though you've already settled with the tortfeasor. Then it said, you can still get that BRB, even though it'll be circular, because the BRB insurer will then go to the tortfeasor, who will then go to the claimant because of their bargain for agreement to buy their piece from this case. And the NVRA has no prohibition of a claimant agreeing to indemnify for BRB. And the appellate counsel said that would go against the policies and purposes of the NVRA. I argue quite the contrary, that allowing claimants to bargain for, and the freedom of contract to bargain for whatever settlement they wish promotes early settlement of car wreck cases.
Now, counsel, looking at your release is one thing, and it's very broad, but your indemnity is something else, and the first part of it, you get an indemnity as to any claims asserted by any person. But then you added the language to the end of it against the proceeds, $6,500 out of the $1.5 million or $1 million or whatever coverage you had. And you're arguing that that is not a limitation on the obligation to indemnify?
I'll argue that is a limitation on the obligation to indemnify, but I will say that encompassing in that language is the BRB claim that Nationwide brought. There's no provision in the MVRA that says a BRB obligation.
Is there any? Do you have anything that says that you paid her a BRB, and that was the proceeds that you paid her?
Is there anything?
Was there any designation in here that the proceeds you paid her were the BRB?
The clear and unambiguous language in the settlement agreement that says you're going to indemnify for all claims.
But the claims could have been up to $1 million. Well, you only paid her $6,500, and I just picked $1 million, but I don't know what your policy was.
In the facts of this case, it was $5,737 was the BRB. And another important point is that all the medical bills in this case were paid by the BRB. There were no other claims to be indemnified for.
Well, if you'd paid all the BRB, what's she doing? I mean, what BRB did she actually get from Nationwide? Did she get lost income, or was it just medical expenses? Do you know?
I don't know what percentage of it was lost income. I know the
lost wages. I mean,
the lost wages. The bulk of it was, and maybe all of it was, the chiropractic and medical treatment that she sought.
So the medical provider charges.
Exactly.
So you didn't settle for pain and suffering or anything.
Well, the additional amount from the $5,700 above to the $6,500 is what was settled for the full amount.
Were these charges incurred before or after you settled for the $6,500?
All the medical treatment were incurred before any settlement, absolutely. And what the court found at the lower court, Justice Abramson lower, and the Court of Appeals unanimously, was that this was not a situation where Ms. Coleman was forced to, or coerced into agreeing to indemnify. And the contrary, Ms. Coleman was the only one represented by counsel. Beeline wanted to buy the $6,500 worth of piece from this car wreck case.
But Ms. Coleman also knew that her BRB carrier could never come against her to recover BRBs, did she not?
She knew that. She did know that.
So her proceeds were never going to be subject to recovery for BRB, were they?
Well, I think there's a distinction between the proceeds of the settlement and the receiver of that settlement. The proceeds of the settlement is the money that
Beeline paid. But your language clearly says that she's only indemnifying you for claims made against the proceeds of the settlement.
Which is the proceeds that Beeline paid. And
But it is also true she had no claim against Beeline for the recovery of her BRB payments or PIP payments?
She had no claim for those amounts that are covered underneath that, correct.
So why would the proceeds of her settlement be deemed BRB payments?
Well, the proceeds of the settlement were paid by Beeline. And Nationwide is segregated to all the rights that Ms. Coleman has. And which would include...
Should we presume that Beeline is paying Mrs. Coleman for a claim that she does not have against Beeline?
Well, no, absolutely not. But what the MVRA allows is the BRB obligor, the insurance company, to intervene in a claim against the tortfeasor and recover those amounts. What Beeline was doing was trying to get out of the case completely.
I assume your position, Mr. Byrne, would be that if Ms. Coleman's lawyer had wanted to protect that fund, he could have. He could have negotiated that aspect of it and kept her BRB free from claim simply by probably, if you all were so anxious to settle it for $6,500, that could have been a negotiated item in the contract and just simply was not.
It was a negotiated part of this agreement. Now, if Mr. Cox, Ms. Coleman's counsel, did not want to include it in the indemnity, he could have expressly stated that, which happens quite often.
Who drafted the indemnity?
The indemnity agreement was provided by Beeline through its third-party administrator. And again, in the Abney case, this court decided a couple of years ago, and what the appellant has raised is that because it's a former lease, then it has no effectual, no language. That was rejected by this court many times. Just because it's a former lease does not make it any less enforceable.
Sent by your third-party administrator to Ms. Coleman's lawyer.
That's right.
And Ms. Coleman's lawyer, in fact, notarized her signature on the document.
That's correct. And Ms. Coleman admitted through discovery that she received the agreement before payment was made and signed it with the advice of counsel. One final thing, that the appellant has argued that if this court enforces this agreement, then it's going to wreak havoc on other car wreck claimants or car wreck victims, as they stated. Quite the opposite is the case. If this court does not enforce this agreement in accordance with its terms, then indemnity agreements throughout the Commonwealth are going to be invalidated, and the MVRA's promotion and policies and purposes of reducing litigation and agreeing to settlement would be discouraged.
What if the response were that we've never seen that language before in an indemnity?
Pardon?
What if the response were we've never seen an indemnity limited to the proceeds of this settlement?
Well, there are all sorts of, you mean other settlement agreements?
Yeah.
If it's broad language that includes all these claims, then it
Broad
will.
language just stops with claims, and that would have covered what you're arguing. But you wouldn't have added the proceeds of this settlement.
Well, I submit that it does include against the proceeds. The BRB obligor does not have a claim against Ms. Coleman, but it certainly has
Just
a claim
saying that
against
you're
the...
suggesting that this is affecting a lot of cases. I'm just suggesting that a lot of people would say that the broad indemnity stopped with the word claims. Any claims, period.
Well, I think it includes the against all proceeds of the settlement, because it's the PIP obligor, the BRB obligor, has a claim against Beeline. It has a claim against the amounts Beeline is paying. That's the proceeds of the settlement, but does not have a claim against Coleman.
Because we're questioning you so much about this, that it's at the very least an ambiguous term?
I don't, that against the proceeds is ambiguous?
Certainly. I mean, you seem to view it one way. It's possible some of us view it another. It's at best ambiguous.
I don't believe that is ambiguous under the MVRA.
Well, doesn't the proceeds of the settlement just define the scope of how much she has to indemnify? It's no bigger than what she got in settlement.
Right, you would not want to have a situation
She
where...
wouldn't be required to indemnify for any more than what the proceeds of the settlement were.
Right.
That was the scope of her obligation under the contract.
Exactly. You would not want to have a situation where someone got paid $3,500 and then was owed $10,000 on top of that. That's exactly right. Thank you.
But the language says claims against the proceeds of the settlement. Why is Nationwide's claim against Beeline a claim against the proceeds? They just want their payments back. They don't care if it comes out of these proceeds or not, do they?
Well, because they have a claim against the proceeds that Beeline paid. When you have a settlement...
The claim is against Beeline, and they've asserted that claim. Nationwide is not a third party making a claim against the proceeds of the settlement.
I think they are. They're making a claim against Beeline, which is the proceeds of the settlement, and they have that claim because they're subrogated to Coleman's rights for that portion of the benefit.
Then they have a claim, but their claims against Beeline, not against the proceeds of what Beeline paid to Mrs. Coleman.
Well, I think it's the same thing when the $6,500 was paid that included the BRB of $5,700.
But that's the question, did it include the BRB?
Exactly. I submit that it does when Beeline wants to buy their piece from the entire car wreck claim. Thank you, sir. Thank you.
Mr. Clark, you have 3 minutes.
Thank you. May it please the Court. I just want to answer a few questions that were raised by the Court. Justice Minton, Chief Justice Minton, I believe you had mentioned Rochelle and said, well, how is Mr. Byrne distinguishing Rochelle and the specific designation of no-fault benefits? Well, the answer, I believe, is this. How can Rochelle make any sense if it requires a specific designation of no-fault benefits? But then when you insert an indemnity clause, magically you don't need that information. You don't need a specific designation of no-fault benefits. It can just run silent on it. That's absurd. It doesn't make any sense. The indemnity portion of Rochelle is dicta. It in fact says that. It says the indemnity claim in this case is entirely speculative.
Well, in fairness to the dictum, it says exactly what this case is about, doesn't it?
Well, it doesn't predict anything.
But it says the very scenario that's described here is exactly what may happen.
It says may happen, yes. It says it's entirely speculative is what Justice Leifson used. Those were his words. But it doesn't make any sense. You have to read that language in conjunction with the rest of the case. And the rest of the case says you have to specifically designate the no-fault benefits. The insertion of an indemnity clause isn't some sort of magic that converts that to not included at all. And I think this raises another point when we're talking about past releases that have been signed over the past 15 years, the contractual limitations period for written contracts. Those were executed based on the language of Rochelle, and they were executed based on the language of the Motor Vehicle Reparations Act. So what Mr. Byrne is proposing, it's the exact opposite. It could invalidate those. It could require indemnity against no-fault victims. And you'd have to create more courthouses for all the cases that are going to be filed, interestingly, by the insurance company against the accident victim or their attorney, as the case may be, for malpractice. That's unacceptable. And that's what this case is about. That's what's at issue. It's huge. If they're right, there can be tens of thousands of lawsuits for indemnity.
Or there could be negotiated those terms during settlement.
Well, if they specifically designated BRB within the scope of the settlement, within the scope of the release, which they didn't here, I mean, there's no contention that BRB, no-fault, personal injury protection, PIP is anywhere mentioned in the correspondence between the parties or in the general release itself. That's not even at issue. So, with that in mind, the Court of Appeals opinion has to be reversed. This case should be remanded to the trial court as well for the counterclaims that we've asserted. Thank you very much.